dog. Well, not only that, but you're not going to be able to do that with this cadaver dog portion of it.
The intent here is not, of course, to have Lieutenant Azell speak beyond his expertise. I know that he doesn't know handler science, or at least I'm not expecting to elicit anything along those lines. But I believe, based on the reports I reviewed, that he was present when the dog alerted, the bones were collected, and then taken out and discovered to be animal bones.
Again, the fact that you have a problem with the dog finding bones. Oh, I'm sorry. Well, no, this is Azell.
No, I understand that the court ruling.
All right.
I think the court ruling is just that dogs and reliable. And what the institution that some other dogs not certified or you don't even know.
Okay. That wasn't my question. My question was, do you object if it's just a dog found some bones as opposed to the cadaver dog?
Yes, because my request is to be bones found and basically that
Okay.
The basis of my request is that we have had similar testimony as to what Your Honor is suggesting could be a way of presenting this, which was through Patterson, the dog Kiki, finding a bone on the mountain. It turned out to be one of Dylan's bones. But that type of evidence has come in, elicited by the prosecution, and it was human bones. I think that I would keep it limited to you observed the dog alert, you saw the bone that was collected, the bone turned out not to be human.
Yeah, but there's no reason to even mention the word dog unless you're trying to make it look to the jury as though dogs are inaccurate, which hopefully you have your own experts, and we've also been doing as much cross-examination on that as possible, it seems like. So I'm going to eliminate or prohibit you from talking about the fact that the dog found it just because it was found a certain time.
Understood.
I do too. Thank you, Ms. Branson. Second one up. It'll be a minute or two. Yes. In fact, I need my water anyway.
Mr. Moran, is that also a video?
No, that is Celebrate.
What's the age of the
Page 1.
Thank you. Everybody rise, please. Yeah, what up here? We can be seated.
Your Honor, may the witness approach the stand?
We're not on the record yet?
Okay.
I was gonna put it on the record. Mr. Zell, come on back up. You're still under oath. Go ahead, Mr. Marin.
Thank you, Your Honor. Good afternoon, Lieutenant Zell.
Good afternoon.
My understanding is that as the supervising investigator, as the lieutenant, that the buck stops with you on this case. Is that fair?
Yes,
And you were supervising other investigators who worked on this case, obviously. That's right.
yes,
And you assigned lead investigators over time. Is that right?
at the very beginning I did, yes.
So were there multiple lead investigators as this case moved through the different years?
Counting myself, I believe there were 3,
Those 3 separate lead investigators?
yes.
There was some testimony on direct with respect to days that you calculated Mr. Redwine was present in town and that Dylan could have been with him. You recall that testimony, obviously.
Yes, based on the work schedule.
But there were other sources of information available to you, so you would agree with that, right? With respect to when Mr. Redwine was in town, at the same time Dylan was in town, to be specific.
Could you show me what you're talking about?
Sure. Permission to publish People's 480.
Sure.
So you calculated somewhere in the neighborhood, 93 days that Mark and Dylan, or at least that Mark was in town and could have been with Dylan in Durango, right?
I believe it was 94 days just based on the work schedule.
But you did not include in what you described for the jury the occasion on May 27, 2012, when Dylan was in town visiting his father, spending time with his father. Is that fair?
Objection, Judge. I think that mischaracterizes the evidence.
Well, you can, Mr. Rizal can, or Lieutenant Rizal can correct him if he's wrong.
So your testimony did not include the fact that Mark and Dylan were together in Durango on May 27, 2012, right?
This refreshes my memory here. I did not recall this text.
So on this occasion, that was not included in your description of times when Dylan and Mark were together. We have proof that that is inaccurate. So the description of times worked and when Mr. Redwine was in town, at least on this score, is wrong. Do you agree?
Yes, at least on this score.
I could trouble counsel to go to page 6. This text exchange between Dylan and his father, Mark Redwine, demonstrates another occasion on which Dylan and Mark were in Durango and interacting with each other together. Would you agree?
It's my understanding from this that Dylan was in the Durango area, but not staying at Mark's house.
If I could have counsel, so your testimony now is that Dylan and Mark weren't staying together at the time?
It's my understanding that Dylan was staying at a friend's house.
If I could have counsel scroll to page 5. This would indicate that Mark is picking Dylan up, right?
Yes, but not at his house.
But you didn't include this as one of the occasions that Mark was in town and spending time with Dylan, right?
At his house.
No, that wasn't the testimony. The times that Mr. Redwine was in town based on the record from Mr. Redwine's employer. Times when he was in town excluded this date, correct?
For the purpose that you're describing, yes.
And this was, in fact, an occasion Mr. Redwine was in town in Durango, right?
Yes.
I can have that taken down, thank you. Lieutenant Izell, as the supervising lieutenant on this case, you would agree that making compilations and summing things up, that it's critical to be accurate.
Yes.
If I could have counsel play that video that we discussed, it's People's Exhibit 360, the time on it. I forget what we talked about, maybe 2:40, 2:35. Anything before 2:45, then 10 seconds. It's fine. Can I have you start just a little bit forward? Well, this is fine. For the record, this is being started at 2:30. My understanding is that we're looking to the south.
Is that a question?
Yes, Lieutenant Zell, at this minute mark, are we looking to the south from Rumlet Park?
Pretty much to the south, southeast.
Could begin this, please. And Your Honor, may I have permission to move about the way?
Yes, go ahead.
If I could have a pause here.
Take the microphone, please.
So this clearing that we're seeing here kind of extends as we'll spin more towards where you park the road is at the top of the image. That probably makes it terrible record. Anyway, are you following me?
Yes.
That this clearing is sort of separated by this aspen grove, and then there's another clearing. Headed towards the north.
And can you read what the time is on it?
Yes, 2:41. It's panning to the north, correct?
Yes, it is.
And my understanding of your testimony was that you're not finding animal bones. Do I understand you correctly?
No.
All right, if you keep rotating it. Your Honor, I'm sorry to interrupt.
You stop it for a second.
Yes, that answer and that colloquy was unclear to me.
It was unclear to me too as to how he was answering though. So could you clarify that?
That's fine, and I think that we were a little bit too far to the south and at any rate, as we get this way,
Well,
it'll be more clear. So I can withdraw the last question.
all right, the jury can disregard the last answer then. Go ahead.
I'm sorry. And it's at 2:46, if I got count started again. Stop it here, thank you. So we're at the 2:minute 53-second mark, right? Is this the area you were describing that you're looking around in and not finding anything?
That is not. The area that I'm referring to is the immediate vicinity of where the skull was recovered.
So that's approximately right in here.
No.
Okay. Is it going to be at all on this video?
I'm sorry, is what going to be on the video?
The location of the skull?
Yes.
Okay. You keep moving it. Oh, I'm sorry, stop again. So 2:54. Then you would agree that this area here is covered in animal bones.
I would not say covered, but there were animal bones up in Runlet Park in the meadow and up on the ridge in the tree line up in there. But the area I'm referring to is the immediate vicinity of where the skull was located, which is approximately under the drone. There were no other bones in that immediate vicinity.
I see. And what radius were you describing around the skull?
Well, we went approximately 200 feet down below the skull and worked our way back up. Did not find any animal bones through that area.
So from the drone is positioned in this image directly down, is that right? From where the skull is, like it's across the GPS location?
It's generally above that location. I can't tell you if it's precisely over if the wind was blowing the drone around that day.
Okay. Fair to say, though, that an individual walking around from the road to this area would find all kinds of bones.
Again, the characterization of all kinds of bones is not something that I would say, but if you walk across that meadow from Middle Mountain Road, you will find animal bones scattered about, mostly cows. And once you get into the tree line where the skull was located, I found no bones except for the skull.
So in this area, you're finding cow bones. Did law enforcement ever determine what was eating those cows?
No.
I could have counsel take that down. I appreciate your queuing that for us. Thank you. And just to get real complicated here, I'm going to ask to publish Defense Exhibit 1893. July 16th and July of 2016 and August of 2018. So there was obviously the occasion when you were there with the Fosters in 2015. Were there others?
Yes.
And how many people were involved?
The number of people varied depending on what our specific purpose or mission was on those given days. we had anywhere from 3 or 4 individuals to up to a dozen.
And so besides July of 2016 and August of 2018, when?
Don't recall the specific dates, but we went up into that area several times. I've been up into that area multiple times by myself. Back in June of 2013, when we did the search of Middle Mountain Road, we had search teams that started in the Runlet Park area.
I could have council go to 517, people that did it 517. Permission to approach?
Yes.
If I understood your direct testimony, you acknowledge that this exhibit is an approximation, first of all, right?
Correct.
And that this isn't to suggest that there have been boots on the ground on every area that's marked here in this peach type color, right?
That's correct.
And if I understood your direct testimony properly, you described that this space in here was searched by helicopter. Is that right?
That area in there, portions of it were searched with boots on the ground, and portions were searched by helicopter.
There's an area below this that has not been marked. Is that all area that was searched by helicopter?
I couldn't say specifically if they flew into that drainage there. What I can tell you is that we had teams go down the cliff face on ropes.
Given that this is an approximation and is not the sum of everything that's been searched, is it overbroad or underbroad?
My belief is that we could show some additional areas.
But the description on direct examination was that, and this has been repeated throughout the trial, that we have essentially impenetrable landscape. Would you agree that that's been testimony you've heard during the pendency of this trial?
I have heard that and I have seen it.
Okay. So that you would agree with that testimony that what we're talking about here is so much deadfall, so cliffed out, that this is not a space that a human could traverse.
I think a determined human could traverse it, but it is full of cliffs and deadfalls, very rough ground.
So you still have not crossed the bridge and hiked the waterfall trail, have you?
If you're referring to the trail that's coming off of Black Bear Lane, it's my understanding that trail was not in existence as an improved trail in 2012.
My question was, you have still not walked that trail, have you?
I have not walked such a trail.
And you would agree with me that some of these areas were cleared by by helicopter.
Yes.
If I could have council go to exhibit 362, and I'll be looking for the 15-second mark. Yes, sir. This is 62, I think. The screen reads site number 1, Redwine Home. There's an X marking Mr. Redwine's house. This is drone footage. We're starting with a 05 second mark. I can have you say something. What we're doing is going straight at the cliff. Agreed?
Mostly straight at the cliffs, yes.
Had we gone south, there would not be, it wouldn't be as clipped out as we see sort of center left in this image, right?
That's correct. There's not near the size of cliffs in that area if you turn further south.
And this waterfall that we keep talking about is because there is a stream that creates a watershed that would be less impenetrable than these cliffs going south, right?
I wouldn't say less impenetrable, but I would say less steep.
Less steep. Is that right?
Less steep than cliffs, yes.
Okay, you play. Come on. So we're stopping here at the 15-second mark. You agree that this drone is not taking a bit of the dog leg, we're moving to the left with the drone, right?
I can't tell you if that's an intentional move on his part or due to the wind at that level, but yes, the drone is actually making more of an angle towards the Site 2, which is the purpose of this video.
So the operator was not instructed to fly the drone at the cliff?
The operator was instructed to fly the drone towards Site 2, which is just beyond the cliffs.
Was there any discussion about taking the most direct route?
That is the most direct route. We're talking a straight line.
Right. Okay. So that's what the drone operator was instructed to do?
Correct.
Is that a drone that you can program the GPS into?
I'm not familiar with the drone operator's equipment.
I can have that played here, please. Can I have you stop it here, please? So we're stopping here at about the 43-second mark. You would agree that to the south, so towards you in this image, that's a plateau would make it sound too flat, but it's not. It's not like this section that's on the left side of the street. To the south, you could walk without significant elevation gain.
I can tell you that the difference in terrain from the location of Mark's residence, which is about 7,800 feet.
So but what I'm talking about here is, I think plateau is actually an appropriate term for what would be to the south. There would not be another cliff band to the south for at least a month.
There's not another cliff band right through that area, but the elevation is still the same.
If I could just have you play it for a few more seconds. Thank you. Okay, stop, thank you. At about 57 seconds, the drone that had gone to the left to take in those beautiful cliffs is now cutting from the north back to the south. Would you agree?
No, I would have to watch that again. I didn't see what you're talking about.
That's fine. I can keep playing. I think that's sufficient. Thank you. There was some description of how the drone operator had to relocate. That's because the drone operator started at Mr. Redwine's house. Is that right?
That's correct.
And I beg your pardon for jumping around a little bit here with this, but when we were looking at the Runlet Park area, the first images and video that was being displayed a moment ago, you had testified on direct about the two-track road. Do you recall testifying that that ran to the west of the Runlet Park area where the skull was found?
It starts basically in the north and runs to the west, all the way down the mountain. It becomes a very broken trail until it reaches the area of Five Branches Camper Park at the north end of Vicito Lake.
Above the area where the skull was recovered towards the two-track road is steeper than it would be to come down from Runlet Park, or the road up there. Would you agree?
Yes.
So it's an easier route in from Runlet Park and Middle Mountain Road than it would be from that two-track. Would you agree?
Not necessarily. It would depend on where you're at on that two-track road.
You made some mention on direct about Mr. Redwine not participating in searches, but you're aware that he was organizing searches, right?
I'm aware that he attempted to, yes.
And he had an individual with a dog team that was willing to work with him. Her name's Wendy Kessinger.
Yes, Wendy Kessinger.
And in fact, law enforcement, the Plata County Sheriff's Office said, we'd rather you not, because Wendy Kessinger had fallen out of favor with the Sheriff's Office. Is that a fair characterization?
No.
Is it fair to say that at one point, law enforcement had been working with Wendy Kessinger and her dogs?
We worked with Wendy Kessinger in December of 2012.
And at some point, law enforcement determined that Wendy Kessinger was not someone that would be used in further searches. Is that right?
We had reason to believe that she was not reliable.
And that information was conveyed to Mr. Redwine while he was planning his search with her offer to volunteer and help.
I'm not aware of that.
With respect to things that, I mean, Lieutenant, I get that we're all just human, so you can't be aware of all of the things that are happening in an investigation, but you were aware that Corey Redwine had remarked that law enforcement asked him to stay out of the way. You're aware of that, right?
I heard him testify to that, yes.
But you were never able to identify the law enforcement official who you were ultimately supervising who conveyed that information to Corey Redwine, right?
At the time, I had no reason to do that because I didn't realize it had been done until he testified to that fact.
And in a similar vein, you've not been able to identify which law enforcement official told Mr. Redwine that, right?
I specifically asked that question of my investigators, and the response was in the negative. Nobody told him that.
There were lots of types of sheriff's office deputies and personnel working this case. Agreed?
We had jail deputies, patrol deputies, and investigators.
And additionally, multiple agencies, correct?
We had several different agencies from this area and, excuse me, and from out of the area assisting us.
But suffice to say, at least amongst your crew of investigators, they didn't recall saying anything like, it would be best if you stayed out of our way.
My investigators and some patrolmen were the only personnel that had contact with Mark that I was aware of.
There was some testimony about the work at Mr. Redwine's house, and when Ron Armstrong was finished, provided, and then later a certificate of occupancy was provided. Do you recall that testimony?
Yes, I do.
But you were also present when Ron Armstrong was testifying and saying that the house, the work was completed soon after he completed or got the authorization to proceed done in April of 2010, a full year before the certificate of occupancy, right?
That he completed the work in April of 2010?
Well, that he said it just took him a couple of months after he had an authorization to proceed, and that would have meant that his work was complete sometime in 2010.
Mr. Champagne?
Objection, Judge. I think that mischaracterizes the testimony of Mr. Armstrong.
Well, you know, there's been so much testimony, I personally don't remember. So I can't rule on that, but I think that's up to the jury to remember. You've made your point, and they'll remember what Mr. Armstrong stated in their collective memories. Go ahead.
The basis or the day that you used to start the possible days billing could have been at Mr. Redwine's house was in July of 2011, though, right? When you come up with this calculation of 94 days,
I believe it was starting from April 22nd of 2011.
but it was that certificate of occupancy. That's why you started it there.
Correct.
On June 26, 2013, you were in the area where the femur, tibia, clavicle of Dylan has been found. Do you recall that?
Yes.
You were with an ICE agent, investigators Gabbard, Dyer, and someone by the name of Hutchins. Does that sound right?
I was with multiple people. We had a large search party.
And on that day, you were part of discovering the bones of a cow, right?
Yes, over behind the gravel pit.
The bones were strewn about, fair?
Yes.
And it wasn't the full skeletal remains, right?
I don't believe it was. They were quite dry and sun bleached. It's like they had been there for an extended period of time.
Did you ever find the rancher who was missing that cow?
Did not look for a rancher who's missing a cow.
Or how about the ear tag of that dead cow?
Did not look for an ear tag of a dead cow.
Did you find any ear tags of any of the dead cattle that are up between Remain Site 1 and Remain Site 2?
Did not see any ear tags of any cattle up there.
On the day that you went to Remain Site 2, you were with Lee Foster looking for the skull. This would have been November 2nd, 2015. Does that orient you?
Okay.
You searched the area for 4.5 hours, is that right?
That sounds accurate, yes.
And then you were certain you were in the right location based on what you were being told.
Towards the end of the search, yes.
And on that day, you found 2 long bones, is that right?
I'm sorry, I don't recall.
Refresh your recollection to take a look at the report.
Sure.
Commissioner Approach.
Yes.
page 5994.
Okay.
Fair to say that you located 2 long bones that were documented with photos and GPS?
We did, but that was not at the site where the skull was located.
It was that day when you arrived in the search area at Runlet Peak with Leah, right?
Correct, and I can show you the entire area we searched if you'd like.
You write in the sentence where you're talking about the long bones, we were certain that we were in the correct area.
Hold on. Your objection.
He doesn't get to just simply read the report into the record. That's
Right.
not how this works.
I think that's right.
At the time that the long bones were found, were you certain that we were in the correct area based on the description Leah provided?
Based on the description that Leah provided and the area that she led us into, we were certain that we were in the right search area.
And in that search area, located 2 long bones documented with photos and GPS, right, sir?
Well below the site of the skull.
One of the things that you looked into in 2016 was to contact Colorado State Patrol about DUI contacts in the Vallecito area,
Objection.
right?
Is this relevant objection?
Relevance beyond the scope.
We had a long talk at the bench about how this scope was created by Mr. Champagne's questioning.
All right. And you're gonna have to come up then. Go ahead.
Thank you, Your Honor. Lieutenant Ezell, in getting work records for Mr. Redwine. You also learned that vehicles he drove for his employer had GPS units, right?
Objection, Your Honor, beyond the scope.
Well within the scope of.
It goes into the extent of the investigation. Middleman.
That's fair to say, right? There were GPS devices on the vehicles Mr. Redwine was driving to the locations in the exhibit that was admitted on direct examination. Fair?
Yes, I was aware of that through other investigators.
And similarly, at least this has to do with United Pipeline, you're aware that Mr. Redwine on the morning of November 19th drove the Chevy to United Pipeline, right?
The white Chevy, yes, his personal vehicle.
And to your knowledge, was any transfer evidence found in that Chevy?
We're so far beyond the scope. I'm not even.
That's beyond the scope.
Yeah. What's wrong? The exhibit provided to the jury, number 361, has images of bones that were in fact recovered, right?
Could you remind me which?
361, sir. I have a copy if that's not sitting handy. It's got a skeleton on it with red.
Yes,
And that demonstrates bones that were recovered, correct?
throughout the searches, yes.
And it demonstrates, it shows the earbuds, is that right?
Yes,
And a GPS location was taken at the time those earbuds were recovered, is that right?
yes,
Same thing with the hair that is on this People's Exhibit 361, GPS coordinates were identified.
it's my understanding they took a single GPS reading for that site between the two deadfalls.
Sir, do you have that GPS reading in front of you?
I do not.
I take it you do not recollect the 12 number location of those items.
That would be correct.
If I showed you a document that Mr. Heidel and I believe yourself helped create, would that refresh your recollection?
I don't know that would help me remember what the numbers were, but it would tell me what the numbers were.
I'm going to object, Judge. I think this is cumulative. It's beyond the scope. 401, 403. It's not really relevant to anything.
But it would help if I understood what you were doing, Mr. Moran. I don't understand where you're going with this.
Judge, the location and items to include earbud and hair were admitted on an exhibit. There was another item located at the precise GPS location that was not included in what's been provided to the jury, and we intend to do so. I want this investigator to confirm that when they created a document that was the data for Google Earth exhibits provided to the jury, that data was correct, and it's missing one item, which is at the precise GPS location of items described and the data points that are at the
If
GPS.
it's already in, it's already in. I don't think we need to go any further with this witness. If you're going to introduce it to another one, that's great. In terms of what you think is missing, were you going to ask this witness what was missing? I mean, you also, and, I mean,
At some point, it may be this witness.
okay, well, you can do it in your case in chief if you need to.
Permission to approach.
Why? I thought
I'm sorry, to approach the witness. I want to provide him an exhibit to see if he can identify it.
all right. And what exhibit is this? Okay, and it's previously been admitted? Okay.
Sir, do you recognize this document?
Yes,
Was this a document that you helped create?
yes,
Was this document created to demonstrate what the as precise as you could make it, locations of items of evidence, where they were recovered and their description?
Yes, based on the information I had.
And is this a fair and accurate representation of a document that you created and you used or was used by the prosecution to create a Google Earth image that's been provided to this jury?
Yes,
And would you agree with me that the GPS or location description for the earbuds is north 37? So this is item 209, if you're following at home.
yes, I'm with you.
All right, earbuds, Patterson, GPS location is north 37, 28.798, west 107, 31.876. You agree with me that that's the same number
Yes,
on your document?
yes.
Then I'm going to ask to admit this piece of evidence.
Mr. Champagne?
Judge, although I think that that was probably improper, I'm not going to object just to save time and keep things moving forward.
All right, it's admitted.
So to reorient you, the remains depicted on 361 obviously do not include a spine, right?
Correct.
A spine was never found.
No human spine was ever found.
And other parts of the child that would be in contact with, for instance, a backpack, were also not recovered, right?
Could you rephrase that?
Sure. For instance, the left clavicle or other parts of the child's upper body were not recovered as far as you know, correct?
To my knowledge, everything that was recovered is depicted on this chart.
Thank you. But you believe that it is not out of the realm of probability that there could be some other items of interest or evidence or remains in the area of Middle Mountain to Runlet Park. Agreed?
It's a very large area, very large mountain.
So you agree with the statement that it is not out of the realm of probability that there could be some other items of interest or evidence or remains in the area, correct?
I don't object. It certainly requires speculation.
I don't think so. You can answer the question.
I suppose there could be other things up there that we are just unable to find for any number of reasons.
And you would agree that you have specifically testified to the statement, not out of the realm of probability that there could be some other items of interest or evidence or remains in the area. Speaking about Middle Mountain, right?
Specifically what I just answered.
Thank you. That's all I have. And I appreciate your patience. It was to comply with court order.
Redirect.
Thank you, Judge. You searched that mountain over and over and over again, didn't you?
Objection leading,
It's all right.
vague.
No, it's not.
Is that a fair description?
Yes, I put a lot of individual and group miles on foot in many places over the mountain.
You were looking specifically for things like the phone, the backpack, other items related to Dylan.
Correct.
Did you ever find any?
No.
Counsel asked you why you didn't ever hike on the waterfall trail. Could you clarify that answer for me?
Yes, it's not a trail that I was personally aware of, and to my knowledge, that trail was not in existence as an improved trail of any kind in 2012.
If I may, I'm going to object to the witness providing information that's beyond his knowledge.
Well,
which is the second part of
you
the
already
answer.
you already got it out. That's already in front of the jury anyway. So you're overruled. That was an answer that he gave to your question on cross. Go ahead, Mr. Champagne.
Sorry, complete your answer, investigators.
That is my answer.
Okay. But the trail did not exist in 2012-13?
To my understanding, yes.
But you did search the Vallecito Trail that goes north directly from Mark Redwine's home.
Yes, that was searched. ATV trails in the area were searched.
And you specifically referred to searching the area of the cliffs and below the cliffs, is that correct?
Correct.
And how was that done? You said something about ropes?
Yes, we had personnel on top of the cliffs. We had personnel rappelling down the cliffs, and we had personnel on the ground underneath the cliffs on foot.
I want to be clear with you back to the beginning of the cross-examination when we were talking about the number of days that Mark Redwine's work schedule showed that he was in Colorado. Counsel told you or asked you that it was critical to be accurate on that, correct?
Yes,
And when you were testifying during direct, were you testifying to his work days, known work days in the state of Colorado?
just work days according to what the schedule showed.
And that was 94 out of 577?
Correct.
And you only know that Dylan Redwine was in Colorado. I believe you've heard testimony that he was here for the Memorial Day trip. Is that right?
Correct.
And counsel asked you about, I think, asked you about the Labor Day trip. We know about those, right?
Yes.
Are you aware of any other times that Dylan Redwine was staying at the Vallecito house specifically?
I'm not specifically aware of any other times that he would have been at the house.
No further questions.
Any questions from the jury? Okay, Counsel. All right, Lieutenant Giselle. There were GPS tracking devices mentioned about being placed on Mr. Redwine's vehicle. Does that mean the two trucks, it says he owns, but I think one was, well, you can clarify. The two trucks involved anyway, Let me read this over just a second. The 2 trucks he owns had tracking devices since he used them for work travel. Do you understand the question? Because I'm not sure I read it very well.
No, I do not.
Okay. So were tracking devices placed on both trucks, if you know?
Yes,
Was one of those his work truck,
no,
just his personal trucks?
just his personal trucks. His work truck was at the office, and that's where it remained.
Okay. And if that doesn't answer the question, you can send another question down. So any follow-up on that?
If I may.
Yes.
Are you aware of the date range in which those GPS trackers were placed on his personal vehicles?
At one time, I was aware. I can't recall the date range now.
Okay. Would it be fair to say it was within the first few days or first few weeks of the investigation?
Yes, first few weeks, maybe a month or two.
Okay. And to your knowledge, did those trackers produce anything of evidentiary value in the case?
They did not.
No further questions.
Anything, Mr. Moran?
To be specific about that, did not have evidence of Mr. Redwine driving up and down Middle Mountain Road, depositing things at Remain Site 1 and Remain Site 2, correct?
Wouldn't be able to address the depositing things portion of the question. However, given the location and the type of equipment that was used, the variables on error distances was quite large.
So the answer is no, you did not have any of that evidence derived from the GPS systems that your agency installed, correct?
Correct. When he was up above in that area, I couldn't tell you if the GPS location was putting him right at his house or further away from his house.
Did not have GPS location information to put him at Runlet Park, right?
I think that's the best answer I can give you, what I just did.
Okay. So between, the question mentions work trucks. So law enforcement had the GPS tracking devices on Mr. Redwine's personal vehicles, but also when you were in touch with his employer, became aware that the vehicles he drove for work also had GPS on them, right?
Correct, and those were left parked at his workplace. They were not at his residence during this time period.
But you were able to tell, based on work vehicle and personal vehicle, where Mr. Redwine was, right?
Taking into account what I explained about the margin of error on distances, I couldn't tell you the exact pinpoint area where he was.
Whose GPS devices were those?
I believe they're property of HIDTA. HIDTA, HIDTA,
What's that?
high intensity drug trafficking area.
Those are drug task force GPS units attached to Mr. Redwine's personal vehicles, right?
They were
Judge relevance.
You know, I think you're getting kind of far afield.
Okay, that's enough.
So, anything else for this witness from the jury? You can step down.
Your Honor, I beg your pardon. I don't want any implication that there's drug trafficking
I think the jury.
implicated here.
There is no implication whatsoever of drug trafficking in this case. It's just another portion of law enforcement. So, you can step down, Mr. Rizzo. Next witness?
Thank you, Your Honor. Your Honor, I'll call Jonathan Grusin.
All right. Raise your right hand. You solemnly swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Yes, I do. Thank you. Have a seat.
May I inquire, Your Honor?
So that's how you treat our evidence, huh?
Go ahead, Mr. Doherty.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Can you please state your full name, spelling your last name for the record?
My name is Jonathan Grusing. Last name is Grusing.
How are you currently employed?
I'm a special agent with the FBI in Denver.
How long have you been with the FBI?
I was employed in '96, so it's coming up on 25 years.
Can you please briefly walk the jury through your career with the FBI?
For the first 2 years in Denver, I was assigned to a terrorism squad. And then for the next 17 years, I was assigned to a violent crime squad, which we responded to kidnappings, missing persons, bank robberies, and homicides. And the homicides could be either on federal land or like in a federal prison, or if a local sheriff's department or police department needed our resources, we would come help work homicides as well. For the last about 5 years, I've been doing, still working those missing person homicide cases while working public corruption and civil rights matters.
Bless you. You referenced homicides. You said federal lands or federal prisons. And is that because the FBI has original jurisdiction, that's your territory for those kinds of cases?
That's right.
And how do you become involved in homicides committed in a local jurisdiction or state jurisdiction?
Since 2009 or so, I've represented the Behavior Analysis Unit to Colorado, which is our profiling unit out of Virginia. And I will be involved in consults if a department like a sheriff or police need a consult from our profilers. I facilitate that. Sometimes I'll also come in and help them work the case as well if they need that sort of help. So there's kind of two ways, either working on the violent crime side or helping with the behavior analysis portion.
Your Honor, yes, maybe approach. Yes.
Agent Grusing, back to my question. Oh, sorry, Your Honor, I'm just trying to keep
I
working.
know Boulder doesn't have court reporters, they fall behind time.
That's a good topic for another day, Your Honor. But the fact that I want to move efficiently is a topic that's been true for a long, long time.
I understand that feeling.
Yes, I imagine you.
But
do.
we can quit talking and we'll never get to this,
Is Madam Court Reporter ready, Your Honor?
no, she's writing everything, she's recording everything that we're saying.
No, I understand, but is she ready for me to proceed?
No,
Oh.
because we keep talking.
All right. Thank you, ma'am.
Hold on just a second, because I thought of something funny, but I'm not gonna say it. So, go ahead.
Thank you, Your Honor. You were saying, Agent Grusing, how you get involved in local homicide cases and how the FBI provides assistance, and can you continue your answer that you were giving before we got called up to the bench?
Either one of two ways. I facilitate a consult with our behavior analysis unit, or I come in and work with the request made to our violent crime squad.
Can you give us an example of a case you've worked on in your role with the FBI in helping a local jurisdiction in a homicide case?
Yes, in November of 2018, Kelsey Barrett went missing from Woodland Park, and they're a small department. Our local FBI office in Colorado Springs was helping try to find Kelsey, and they had a request to interview a friend who had come down to see Kelsey's fiance, Patrick Frazee. They couldn't find this woman. Her name's Crystal, and they wanted me to do a phone interview just because I'd worked a lot of these missing person cases. We don't normally do phone interviews, but I was able to get a hold of Crystal. Her last name's Lee, L-E-E, and spent about an hour on the phone with her.
And as a result of that conversation, what'd you do in regards to that case, Agent Grusing?
Crystal did not give me a story that was coherent or made any sense with the details of the investigation, so I worked with local departments to get a search warrant for her residence in Twin Falls, Idaho. We went and searched her residence, and she ended up cooperating towards a indictment against Patrick Frazee for the homicide of Kelsey Barrett.
What did you find during the search of that residence?
Your Honor, I'm going to object to any further inquiry on this line. This is not relevant to the proceedings here.
Mr. Doherty?
Your Honor, I think Agent Grusing is explaining to the jury how the FBI becomes involved in a local case and what role he plays and how that process unfolds in the case. And I think it's important for the jury to understand the context of his involvement in local homicide cases.
Well, I think you've gotten there, so I think you can move on.
Agent Grusing, do you have training and experience in interviewing victims, witnesses, and suspects in cases?
I do.
Tell the jury about that, please.
While working violent crime for over 17 years, that's what we do, is we show up when something happens and we speak to witnesses, victims, and if we can, the suspects. So I had a lot of field training over 23 years of work in criminal matters. And then I also had training from our behavior analysis unit on more of the cognitive interview.
Generally speaking, does the FBI offer assistance and provide assistance in cases involving missing children?
Yes.
And for what ages?
Especially kids, children under age 13, but we will assist a department, child of any age, up to, 17, 18, up to 20. It doesn't really matter. We will offer assistance as soon as a child goes missing, and if that department needs assistance, we get involved quickly because we can offer a lot of resources that that department doesn't have.
What kinds of resources and support can the FBI provide to a local jurisdiction in a case involving a missing child?
We can help them get organized with a command post, which involves our analytical people forming a timeline and figuring out when the person disappeared. We also offer an evidence response team, which I think you guys have heard from already, that will help process a crime scene. We offer cellular analysis, and then we also offer the behavior analysis.
Do you also conduct interviews?
We do.
And tell the jury how you go about conducting interviews generally.
For a missing child, we'll do a very thorough neighborhood investigation, even going house by house, making sure we don't miss any, especially the place where the child disappeared from. Normally it's the residence. We will assist in interviewing the family members, finding family members that weren't there, that sort of thing. Anything that the department is unable to do, we can reach out of state, that sort of thing.
And what's your role with regards to the local jurisdiction, the local agency that's investigating the disappearance of the missing child?
We are assisting them in helping find the child.
Jury's hearing evidence about the disappearance and murder of Dylan Redwine from 2012. Did you become involved in that case, Agent Grusing?
I did.
When did you become involved in the case involving Dylan Redwine?
November 26th of 2012.
How'd you become involved?
I was asked to come down to Durango and assist La Plata County in their investigation to find out what happened to Dylan.
And that's the La Plata County Sheriff's Office?
That's correct.
Had they sought and agreed to receive assistance from the FBI in regards to Dylan's disappearance?
They must have, because I got a call from my boss to say go to Durango.
What did you do after arriving in Durango, Agent Grusing?
I met with the sheriff's office, found out what they had to date, and then we figured that it would be a good idea for me to go contact the defendant.
What date was it that you arrived in Durango, Agent Grusing?
I would think it would be the night of November 25th.
And after meeting with the folks at the sheriff's office, did you come up with a game plan for going to interview the individuals involved?
We did.
And what was your plan?
I would go with a couple of investigators from the sheriff's department, take an agent with me, and offer our assistance to the defendant in helping find his son.
When you say the defendant, are you referring to an individual you then met and now know as Mark Redwine?
Yes.
Do you see that individual in this courtroom here today?
I do.
Can you please point to that individual, identifying an article of clothing that he's wearing for the record?
Sitting to my far left of the defense table, wearing a gray jacket and black shirt.
Record or reflect identification of Mr. Redwine.
Thank you, Your Honor. Agent Grusing, on what date did you first go to the defendant's residence to conduct the investigation?
November 26th.
What was the reason or reasons you wanted to speak with the defendant, Agent Grusing?
The sheriff's office was having trouble rectifying some of his statements with what they believe happened with Dylan, and they were asking for a more thorough interview to be done. As well, there was not a great timeline to find out exactly when he disappeared, and that was my goal, was to speak with the defendant and find out as best I can exactly when Dylan disappeared.
And what was the defendant's relationship to Dylan Redwine?
He was his father.
Approximately what time did you go to the defendant's house?
I don't recall the exact time, but it was late morning or maybe just after lunch. It was around that time period.
Who'd you go with, Agent Grusing?
I went with Special Agent Russ Humphrey, who came up here with me from Denver, and then investigators Tom Cowing and Dan Patterson from the sheriff's office.
Can you tell the jury, please, what happened when you arrived at the defendant's residence?
Well, I knocked on the door, introduced myself. He let us in the house. I explained what I do and why I'm there, and that I'm there basically working on the family's behalf, trying to find out what happened to Dylan, and that we wanted to cooperate with the defendant in this investigation.
What was the reason you said that to him?
Because I did not, throughout my relationship with the defendant, I did not want to be confrontational because I wanted as much information from him as possible. So my goal was to speak to him in a very disarming manner so he would feel comfortable sharing information with me.
What was the defendant's reaction when you explained your purpose there?
He seemed willing to cooperate.
What was one of the first things you asked the defendant to do after you arrived at the house?
Before we started asking questions, I asked him to fill out what we call a free narrative, which is a written statement.
What's the reason you start with the free narrative before getting into questions of the defendant?
It allows him to articulate from beginning to end of the day of the disappearance of what happened in his own words. And we as investigators would not be interrupting him with questions.
What kind of paper or form did you use when you asked the defendant to complete a free narrative of what had taken place?
It's a real simple FBI form that just has a couple sentences on the top that gives him some instructions to be detailed, even small things matter, and just ask him to start writing.
And what are you looking for in having an individual, and in this case, the defendant, write out a statement in their own words?
We're looking for where they provide a lot of detail and then where they choose not to provide detail. What we found is anyone who is wishing to hide something.
I'm going to object on the basis discussed at the bench. Salcido case is the basis for this objection. I can make further record if necessary at the bench, please.
Well, I'm not sure, this is why he's doing it. I'm not sure we're getting into what you were concerned about at the bench. Did you want to respond at all, Mr. Doherty?
If I need to, Your Honor, I can.
I don't think you need to.
Thank you, Your Honor.
At this point, you're overruled.
Thank you.
Your Honor, I think that what was just mentioned is the first part of it, which is acceptable, and part two is where we've got concerns. So.
Well, perhaps, but it's talking about investigative techniques is the way I understand this and why they did what they did. So I'm going to allow it.
Thank you, Your Honor. Agent Grusing, go on, please.
We are simply looking for where someone is very detailed and where they are vague in the written statement.
What's the reason you're looking for details or when someone's vague?
We have found through doing a lot of these over the years that if someone wants to hide something like their time at a bank robbery, they would articulate what they did in the morning around the time of the robbery.
Hold on a second. There's still another. It's the same objection.
I beg your pardon for the interruption, but yes, and it's Salcido v. People, 999 Pacific 2nd, 833, Colorado Supreme Court from 2000. There's also a Colorado Revised Statute 24-31-3091A, precisely on the type of testimony that's started, and I can see where it's going.
2431?
24-31-309-1A.
All Frank and the two attorneys approach, please. All right, go ahead.
Thank you, Your Honor. Agent Grusing, can you go on with your answer that you were giving before we approached the bench? And I could re-ask the question if you need me to.
We hand out written statements to people for two reasons. One is to give them an uninterrupted chance to give us a statement. And the second is it's an investigative piece to see where they're very specific and then where they're vague. And in doing a lot of these over the years, a person is normally vague when he or she does not want us to know about a certain time.
And is that why one of the first steps that you took in this investigation was to ask the defendant to complete a free narrative, a written statement?
Yes,
And you're looking for details, but also vague statements or omissions.
correct.
How long did the defendant take to complete the written statement?
I believe it's about 15 or 20 minutes.
Was he interrupted at all?
He was not.
Where did he complete the written statement?
I believe he was at the table when you walk in the room to my left a little bit.
Your Honor, may I approach the witness with what's been previously marked as People's Exhibit 173? It's also been provided to counsel previously.
Yes.
Mr. Moran, do you need to see it again? Agent Grusing, do you recognize Exhibit 173?
I do.
What do you recognize that to be?
It's the FBI free narrative form.
Is it the form that the defendant in this case filled out on November 26th, 2012?
It is.
How do you recognize it to be the same free narrative that the defendant completed?
He has dated it in the top left-hand corner, written his name, and then signed his name.
Does it appear to be a fair and accurate, in fact, exact copy of the narrative that the defendant completed on November 26, 2012?
Yes.
Your Honor, at this time, the people moved 173 into evidence.
Mr. Moran?
Incorporating previous objections, understanding the court's ruling.
Your previous objections are already of record. It is admitted.
Your Honor, at this point, I would have Agent Grusing put it on the screen and read it to the jury, so this might be a good time for our break before we get into that.
Let's take our afternoon break. We'll start up again about 3:15. Everybody rise to the jury. Right,
Thank you, Your Honor.
Oh, okay.
I assume it didn't go well. Everybody right, please? Right, so you can be seated.
Your Honor, may I continue?
Yes.
Thank you, Your Honor. Agent Grusing, right before the break, we admitted People's 173, which you described as the defendant's written statement. And with the court's permission, I'm now going to publish that on the screen, but also ask you to read it aloud for us as we go through it. You could use the copy in front of you or read it off the screen, whichever you're more comfortable with, okay?
Would you like me to read the instructions also, or no?
Yes, please. If you could start with the instructions.
So go ahead and publish it.
It says Appendix E, free narrative, describe in your own words everything that occurred the day of the
Mr.
disappearance.
Grusing, when you're reading, it's really hard for the reporter to keep up.
Okay,
You're slow.
I'm sorry.
You hadn't gotten there yet, but I could sense it's coming.
Yes, sir.
Okay.
Describe in your own words everything that occurred the day of the disappearance, from the time you got up until the time you went to sleep. Include everywhere you went, everything you did, and everyone you interacted with, whether by phone, on a computer, or in person. Take as much time as you need. No detail is too small. Everything is important.
Agent Grusing, is what follows the defendant's written statement that you referred to earlier?
It is.
Okay, if you could start walking us through this man's written statement from November 26, 2012, please.
Okay, is that about the right speed? Sunday evening, I left to pick Dylan up at the airport at about 4 p.m. I wasn't sure which flight he was on, but Mom told me he would arrive about 5:15 p.m. When he didn't get off the flight arriving at 5:15-ish, I waited for the next arriving flight. Mom texted me about if he arrived. I told her no. Approximately 5:50, the next flight arrived, and I meet Dylan as he entered the walkway. We left the airport and headed directly to Walmart. After I entered, I returned to get my wallet as he headed to the electronic department. After leaving Walmart, we went to get something to eat. I wanted a sit-down restaurant. He wanted McDonald's. We went to McDonald's and headed to the house. We carried in the groceries, and as I put them away, he went to his room to get the DVD player to watch a movie we just bought. We talked about how he was doing in school, how he was adjusting to his new environment, him seeing his friends. We started passing his football to each other, roughhoused a little, and I started to see his tension subside. It goes to page 2. After watching the movie a bit, again, we started tossing the football some more. We had talked some more, and he got on his computer, and I remember him talking more about how he had been up till 4 a.m. the night before, and how tired he was from stay at the airport most of the day. I'm guessing about 9:30 to 10 p.m., the movie ended, and I went to bed. He was up, but he was up, but I don't think it was for long, ? At about 5:45, I got up, and I believe this is showered, it says showed, and was trying to run my errand so we could get him to his friends. I stirred about to see if he would get up and go with me or wait. As I thought he wasn't ready to get up, so I went ahead to my office and then to my attorney's, making some calls and checking on Dylan along the way. When I returned, he had gotten up, ate some cereal, and had the TV on. At about 11:30 a.m., I called him to let him know I was home so I could take him to Bayfield. After several hours, I went to see if he was at his friend's and got no answer. So I headed to Bayfield to see if his friends had heard from him since he hadn't returned my calls. They hadn't heard from him, so I became concerned and reported my concerns to the marshal, this mother, I believe he meant to say then mother. I immediately drove home to see if he was here again, went to his friend to be told he had not been seen.
During the time the defendant was writing out this written statement, did you interrupt him at all?
I did not.
Any conversation taking place in the room while he's writing out this version of events?
No.
After he finished the written statement, did you have an opportunity to review it yourself?
Yes.
What were some of the details that jumped out at you in reading his own written statement?
Mr. Redwine was detailed with times as far as the flights arriving, the Walmart, the DVD player. The only time he mentioned guessing was he said, I'm guessing about 9:30 to 10 p.m. And then the only question that he asked was, he was up, but I don't think it was for long. So those seem to be the two vague statements, but beyond that, it seemed pretty detailed.
And he had mentioned roughhousing and starting to see tension subside. Did you focus on those details?
We talked about it, yes.
We're going to get to the follow-up discussion you had with him. You mentioned the question he asked about, I'm guessing about 9:30, 10 p.m. The movie ended and I went to bed. He was up, but I didn't think it was for long, ? Why was that significant to you, Agent Grusing, as you determine what steps to take next in the investigation?
Well, it wasn't real significant to me at the time because I had not spoken with him yet. I just noted it and we continued with an interview. So after someone completes a written statement, I just asked if they're willing to talk it through with me. So that's what we did.
Any detail in the written statement about saying goodnight to Dylan or how their night actually ended?
There was not.
Any real detail, any real detail about their interaction in the morning in this written statement?
He said, I stirred about to see if he would get up and go with me or wait. And that's about it. And then the other was when he returned, he had gotten up, ate some cereal, and had the TV on.
Okay.
Your Honor, any further inquiry along this line, we'll object. The letter speaks for itself. The interpretation violates the best evidence rule. So,
All right, we've pretty much been going through exhibits this whole trial. I'm not going to stop now, so we can keep going.
Thank you, Your Honor. After reviewing the written statement, did you then ask the defendant some follow-up questions?
I did,
Where did that conversation take place, Agent Gruesome?
in his living room.
And this was again on November 26, 2012.
Yes.
Tell the jury how the conversation went, please.
I just asked Mr. Redwine to walk me through what happened. I leave my questions pretty open. And he talked about Dylan was supposed to arrive the previous day on the 17th, but he did not. The flight might have had mechanical issues. And then he was even supposed to arrive earlier on the 18th, but he did not arrive on time then.
Did the defendant share with you any reason that he thought Dylan's arrival had been delayed?
Yes.
What did the defendant say?
He said he thought Dylan's mother, Elaine, might be responsible for the delay.
And what was the reason he offered in explaining why Dylan's mother might have been responsible for him being late in arriving in Durango?
He told us that Elaine did not want the defendant and Dylan to get along well, so she might have been purposely keeping him from coming or delaying Dylan's coming.
Did he then turn to November 18th and Dylan's arrival at the airport?
Yes.
What did he tell you about that?
So Dylan arrived at about 5:50 p.m. Mr. Redwine picked him up. When Dylan arrived, he asked if he could go spend the night with his friend, Ryan, and he was also texting Ryan. Mr. Redwine said, no, this is a family day, and you're going to spend it with me. And Dylan seemed a little upset about this, and Mr. Redwine called it standoffish in the Walmart. So Dylan went one way to the electronics department. Mr. Redwine went the other way, and that was somewhat over him not being able to spend the night with Ryan.
What did the defendant say about Dylan's reaction or what Dylan did since he couldn't spend the night at Ryan Nava's in terms of making plans for the next day?
He asked if he could be taken there the next morning.
What did the defendant share with you about his communications with Dylan before this November trip?
Mr. Redwine said that he had not spoken with Dylan for a couple of weeks prior to this visit, and that was because he took a trip with Dylan to Chicago to watch a baseball game. And during that trip, Mr. Redwine showed Dylan photos of what he called the windmill property. Mr. Redwine explained to us that the windmill property was where Elaine, Dylan's brother Corey, and Dylan had lived in Bayfield. And Mr. Redwine had taken pictures of the poor living conditions there. He showed Dylan those photos, and Dylan got upset. Dylan got on the phone with his brother Corey. He was texting with Corey, and then Dylan walked out of the hotel room.
And the defendant shared with you that he was aware that Dylan had been texting with Corey as a result of that discussion,
That's correct.
and that Dylan was upset and angry about it.
Yes.
Did the defendant share with you that that was the last time they'd seen one another before this November Thanksgiving trip?
Yes, the defendant said that while Dylan was away, when he walked out of the hotel angry, the defendant looked at his phone and saw the messages to Corey. He talked to Dylan when Dylan came back and said that it was right for me to show you those photos because those are poor conditions, and that even made Dylan more upset. So because of that interaction in August, there was not much communication between the defendant and Dylan prior to this visit.
And you used the pronoun he. Are you saying the defendant had looked into Dylan's phone and found those messages?
That's correct.
What was Dylan's reaction upon finding that the defendant had gone into his phone and seen the text messages that he'd been sending to Corey on that August trip?
He was upset. Dylan was upset.
So in terms of that continuing conversation you're having with the defendant on November 26th, what did the defendant tell you verbally about the dinner choice and how that came about?
We didn't go much into detail besides what Mr. Redwine said, that he wanted to go to a nicer restaurant. Dylan wanted to go to McDonald's, so he let Dylan choose. They went to the drive-through, got McDonald's, and then drove to Mr. Redwine's house.
Did you ask the defendant to provide detail as to the rough housing a little bit that he referenced in his written statement?
Yes.
Can you tell the jury about that, please?
Yes, he actually demonstrated for us, the defendant demonstrated for us what happened. He said that he and Dylan were passing the football back and forth between couch to couch, and Dylan would run over, and the defendant would say, I would just grab him with my arm and push him into the couch. He said nobody was hurt, and he motioned that at least once, maybe twice. So he called that roughhousing of them tossing the football back and forth.
And you remember him saying that no one was hurt, no one was injured at all?
That's correct.
And that would, and given your role in this case, be something you'd focus on, of course.
Yes.
What did the defendant tell you Dylan was doing on his computer devices during that time?
He said that, first of all, he said the defendant said that Dylan went upstairs when they got home, got the DVD player, and they put in the movie called Adventureland, which Mr. Redwine had purchased for him at Walmart. And Dylan was watching the movie, he was texting some, and he was messing around on his laptop during the movie.
Let's turn to November 19th. What did the defendant tell you in this November 26th conversation? Took place on the morning of November 19th.
So yeah, we had walked through the picking up at the airport and Dylan going to sleep that night. And then Mr. Redwine continued to the next morning, and he said that he woke up at about 5:45 a.m. Mr. Redwine did. He went in and saw that Dylan was still asleep, just like in his written statement where he said he stirred around. He said he tried to make a little noise to wake Dylan up, but Dylan did not wake up. And so Mr. Redwine then went to go see an attorney and went to his job for a while.
What did the defendant tell you he did in terms of calling or texting Dylan during that time?
Said he both called and texted Dylan to see if he was up, and Dylan did not answer the calls or the texts.
Approximately what time did the defendant return to his home?
11:30 a.m.
And what did he observe upon returning home, according to what he told you November 26th?
The defendant said the TV was on to the Nickelodeon channel and a bowl of cereal was in the sink, but Dylan was not there at the residence.
Where did the defendant tell you he thought Dylan might have gone?
He thought he went fishing with a friend named Tristan.
And what did the defendant do at that point?
The defendant took a nap for a while. He said, I don't remember which statement, it was around 45 minutes, maybe an hour. And then he decided to go look for Dylan after the nap.
And where did he go and what did he do?
Well, he first went to Tristan's house and he was unable to locate Dylan or anybody there. He then went to another friend's house, and then he went to the Bayfield Marshal's office.
And did he also call Elaine Redwine after arriving at the Bayfield Marshal's office, according to the defendant?
Yes.
What did the defendant offer to you as a possible reason for Dylan's disappearance?
He said that he thought Dylan went fishing and he thought he might have run away.
What reason did the defendant give for Dylan running away?
He said he might have run away because of Elaine.
What was your reaction to that, Agent Grusin?
Again, I was not taking a confrontational role with Mr. Redwine, but I did not understand why Dylan would go from Colorado Springs to Vallecito, and then if he had problems with Elaine, run away from Elaine while he's at Mr. Redwine's residence. So I did ask him that question. I said, why would he run away from Elaine if he's at your residence?
What did the defendant say?
That's when the defendant started talking about the poor living conditions, and that's when I found out about the August trip that he had shown the photos to Dylan.
Did you also ask the defendant for consent to search computer devices within his home?
Yes, I did.
Can you tell us about that, please?
We just asked him, whatever, because he told us Dylan was both texting and on a computer, and we were able to, the defendant gave us consent to search those items, as well as, I believe, a laptop or iPad he had.
And between the written statement that you read to the jury, as well as the conversation you just shared with us here, Any mention at all about injuries that Dylan was suffering?
No, the only thing was the roughhousing, but the defendant was adamant he was not injured during the roughhousing.
Any mention of blood at all from the defendant on this November 26th interview?
No.
What stood out to you about the written and oral statements on November 26th as you decided what steps to take next in your investigation?
Well, I thought the August incident where Dylan got upset and did not talk to him for a couple months was important. So I wanted to talk with the brother of Corey to see what happened between them. And then, of course, the defendant was saying Elaine was responsible, so I wanted to talk with her, even though it didn't make sense to me. I wanted to see if that is a possibility.
How long did you spend with the defendant on November 26th, Agent Grusin?
About 2 hours, I think.
What were the next steps you took in the investigation?
Myself, the agent with me, the investigators, we went back and we met and we briefed everybody on what happened. Elaine and Corey were in town, and I made an appointment to meet them at the sheriff's office the next day. And we talked on next steps. And I had left, my contact information with Mr. Redwine. I said, I'm available anytime you want to call. I said, our goal is to bring this to a conclusion, to help find Dylan. You call me anytime. So that's how we left. And then, I spoke with Elaine and Corey to verify the stories that Mr. Redwine told me.
What did you learn from Elaine and Corey in regards to those particular points?
Section hearsay.
Your Honor, it's not for the truth of the matter asserted. It goes to what Agent Grusin does next with regards to the investigation and its follow-up interview of the defendant.
As long as it goes to a follow-up interview, I think that's okay.
Thank you, Your Honor. Go ahead, Agent Grusin, please.
So I spoke with Elaine, and she said that there was a lot of fighting between her and the defendant. She said, however, Dylan was a very easy kid to raise. She said that he's very social, and she cannot see him being without his friends. She also said that Dylan was not looking forward to this visit and sent her a frowny face upon his arrival at the airport. So I also spoke with Corey. I asked Corey about these texts and what was going on during this August timeframe. Corey confirmed what the defendant told me, that Dylan was upset about being shown the pictures of the windmill property, but he asked Corey for pictures of the defendants with feces on his face. And Corey told me that he had those photos, but he did not give them to Dylan when he asked for them in August.
And was the reason you were asking Corey about this because of the information you learned about the defendant going on Dylan's phone?
Yes.
So let's turn now to November 27th. What's the next step you take in regards to the investigation into Dylan Redwine's disappearance?
Myself, the Agent Humphrey, and the investigators went back again to contact Mr. Redwine at his residence to just walk through the timeline again and see if we could get some more detail on what happened.
What's the reason you wanted to go back and do that again?
I wanted to see if anything changed in what he had told me on the first day. I wanted to see his reaction to us showing up. I mean, it is very normal for me to spend days and days and days with a family when someone disappears, because they often want our help to find their missing kid or wife or whatever. So we just make ourselves available on a daily basis to continue the communication.
Approximately what time of day did you arrive at the defendant's house on November 27th, 2012?
It was around the same time, either late morning, right around lunch, or early afternoon.
Was the defendant home when you arrived?
He was.
Can you tell the jury about that interaction, please?
The defendant answered the door, and he was holding a pillow with both hands. His eyes were very red, as if he had either been crying before or drinking. He was more disheveled and distraught than the first day, and he said he'd had a rough time or a tough time.
And what else did he say to you during that first interaction on November 27th?
He wasn't upset with us showing up. I think he said the pillow was something like, this might be the last item Dylan touched or laid his head on, or something like that.
What'd you do then?
We sat down with him and about just like the previous day and spoke with him on the couches and just asked him to walk us through things again for anything new he might remember, that sort of thing.
What, if anything, did he provide you with regards to the trip that they had taken to Walmart on November 18th, 2012?
He provided me with the receipt where he purchased the DVD, the Adventureland, and the other movie for Dylan.
And did you then have another conversation with the defendant about the timeline and the interactions between he and Dylan on November 18th, 2012, and what the defendant said about November 19th, 2012?
Yes.
And what did he say to you during this November 27th conversation about those dates?
His story was pretty consistent with what he had given me the first day on the 26th.
What did he tell you about text messages, if anything, that Dylan had been sending on his way from Walmart back to the defendant's home?
Yeah, I believe he said this is more of the Dylan wanting to get together with his friends. And so he said Dylan was texting his friends on the way.
Who else was present in the defendant's home during this conversation on November 27th?
His brother, David Stone.
And what interaction did you have with Mr. Stone, if any, during this time?
Well, I reintroduced myself to him, told him the FBI's role, and told him why we're working on behalf of the family and how we're going to do this. I gave Mr. Stone my business card and said, same thing, the door's always open, et cetera. So we brought him in as well.
And in speaking with the defendant on November 27th, his story was largely consistent with what he'd said on November 26th.
That's correct.
How long did you spend at the house on the 27th, Agent Grusin?
It was not as long, maybe an hour or hour and a half.
And when you were leaving the defendant's house, how did you leave it with the defendant?
I asked the defendant or Mr. Stone to please contact me, when something comes up, if we'd like to talk further, et cetera.
Did you also make plans to meet the next day, November 28th?
Yes, I said we'd like to meet with him daily, and could he please call me when it's a good time to meet?
And what'd they say in response to that?
I don't remember exactly, but I don't remember them telling me no. They did not, however, call me the next day.
So let's move to the next day, November 28th. You're saying you didn't get a call from the defendant or David Stone.
Correct.
So what steps did you take?
Starting the morning of the 28th, I worked with the sheriff's office to start drafting search warrant for Mr. Redwine's residence.
What was the reason you wanted to get search warrants for the defendant's residence, Agent Grusin?
Well, multiple reasons: to see if we could authenticate Mr. Redwine's story, to see if there was a sign of a violent confrontation there in the house, if something might have happened, to give us any other clues of why Dylan was not there. There's a lot of things to look for. So we had multiple reasons to get a search warrant.
And what was the process for going about getting a search warrant for the defendant's residence?
I just assisted the local investigators in drafting an affidavit, and then they got the warrants and presented it to a judge. I did not.
What steps did you take to check in with the defendant and/or Mr. Stone about whether they were willing to talk with you?
I called Mr. Stone at around 3 o'clock and asked him if they were still interested in meeting, and he just told me they were still thinking about it. So I just left it at that.
So let's turn to November 29th, 2012. Can you tell us how that day began in terms of this investigation, Agent Grusin?
So after getting the search warrants, we met real early with the sheriff's department. Our evidence response team had come in to help process the scene, and we developed a plan of action, and then we were up at the defendant's house by about 8 or 8:30 in the morning.
What was the plan of action going to be for November 29th?
So during a search, if you have your house searched, you cannot be present inside the house during the search. So you have to either stand outside or go to an office or wherever else. And my plan was just to be with Mr. Redwine while the search was happening and see if we could talk some more.
What was the reason you wanted to do that?
I wanted to see what his reaction was to know that the FBI was searching his house.
So can you tell the jury about your arrival at the defendant's home on November 29th and what took place then?
So during our planning meeting, I asked our evidence response team to drive the truck up. There's a lot of space in front of the defendant's house, but to drive it, I don't know, 50 feet or so away from his front door, but so he could see the FBI seal and our truck. It's a big white truck. And the purpose for doing that is going to be the same thing that I explained to the defendant, and that is when we do a search for something like blood, hair, fibers, saliva, it's going to be very thorough. And I explained that to the defendant when he answered the door. I told him we had a search warrant. The truck was behind me. And I said, we're going to be searching the place. We're looking for any sign of Dylan here. And I told him, you know, those items that I described before is what we would be looking for.
What items?
It's anything. It can be hair, saliva, blood, especially, you know, signs that Dylan might have been injured in any way.
Now, you'd met with the defendant on November 26th and November 27th, and he had never mentioned any blood or injuries to you during those two conversations, and three, including the written statement.
That's correct.
Where were you interacting with the defendant when you first arrived at his house on November 29th?
At his doorway. We were at his doorway, or slightly, he might have been stepped outside a little bit as we were talking to him, advising him of the warrant.
And what was the reason you wanted the truck, the evidence recovery team truck, parked within sight of the defendant's front door?
Well, I've worked other cases, and sometimes we don't find anything, but sometimes they, being, if someone was responsible for a violent act, they might admit something anyway, knowing that we might find blood or something that had been cleaned up.
And you explained to the defendant what the purpose of the search warrant was?
I did.
Did you explain to him what the truck was there for?
No.
What did you say you were going to be looking for in connection with the search warrant?
Well, I explained that the truck was part of our evidence response team. I didn't tell him why it was parked there. So,
understood.
Yeah, but no, I explained to him that our evidence response team had a job to do, and, you know, this was going to take a long time. I asked him if he'd rather stand outside or we could go to the office, the FBI office, but I'd like to talk to him some more. And he said, well, if you say it's going to take all day, I'm not going to stand around all day, so let's just go to the office. So he and Mr. Stone went with us to the FBI office in Durango.
And how are you going to get from the defendant's house back to Durango?
I wasn't going, sorry, from the defendant's house to Durango. Yes, the sheriff's department had a Suburban or something like that we got in the back seat of.
After getting in the back seat, what did the defendant say to you, if anything, Agent Gruson?
After I had mentioned the statement about finding blood and our response team is there, it's either as we're getting in the Suburban or we're once in the Suburban, he said that Dylan had a cold sore or an ulcer on his lip that was oozing blood. So that was the first mention of any blood I had heard from him.
First mention of any blood you'd heard from him in the 3 days you've been interacting with him?
That's correct.
And as far as you know, is that the first mention of any blood that anyone from law enforcement had heard in the 10 days interacting with him?
It was.
What was your reaction after the defendant said Dylan had a cold sore that was oozing blood in response to the search warrant that was going to be executed?
Well, I'm trying to work collaboratively with the defendant at this point, and I said, well, that will be easy to verify because Elaine will be able to say there was a cold sore before she put him on the plane, and the flight attendant most likely will have seen a cold sore if it has blood in it.
What did the defendant say then?
He said that he changed his mind, and it was not from a cold sore or an ulcer. It was when they were tossing the football back and forth, and Dylan had tried to catch it, and he had missed, and the football had hit him in the lip, and blood had gone on the floor.
Was that different than anything he had said previously?
Correct.
What did he say Dylan did in this version after his mouth started to bleed from the football hitting him in the face?
I don't believe we addressed it right then. I think I didn't want to question him. I'm in a Suburban right now, back seat with other people, and we were going to talk at the office for quite a while. So it was, again, significant, I thought at the time, because he was admitting there was an injury to Dylan, and I decided we would just address it later.
What was the significance of his story changing from no blood, cold sore, oozing blood, to football hitting Dylan in the face, causing him to bleed to you?
Well, both stories, the defendant was changing what had happened to Dylan to meet what he thought would be evidence. The truck represented evidence collected from the scene that would be collected. And then when he mentioned the cold sore, and I said, well, I could track that down pretty easily, he changed the story to the football.
Any further conversation in the Suburban at that point?
No.
So where did you go?
We went to the FBI office in Durango.
Can you tell the jury where you went when you arrived at the FBI office, please?
So I've only been there once or twice, but you walk in, there's just kind of an office area, and then there's an interview room or conference room to the left, and myself and Agent Humphrey and Mr. Redwine went in there to further discuss the timeline, and of course I wanted to get to the bottom of what happened to Dylan's foot.
And did you then have another conversation with him in that conference room?
Yes.
Can you tell the jury how that conversation began, please?
So we just told the defendant, again, that we wanted to go from A to Z, that we wanted a little more detail on each one of the things, that we're trying to build a really solid timeline for the sheriff's office, and we were just trying to find Dylan. And that was also more of a sharing process where we were sharing parts of the investigation with him, and we wanted him to share a little more with us.
What did the defendant tell you in terms of the timeline in this conversation with you on November 29th?
The first part was basically the same as far as picking him up from the airport, the Walmart. He did offer that Dylan wanted an iTunes card at the Walmart, that the defendant did not buy him one, and Dylan got a little, not greatly upset, but just a tad more upset about not getting an iTunes card. We walked through the McDonald's, even what they had ordered, that sort of thing, and then the drive back to the residence, watching the Adventureland movie again. A lot of that was mostly the same. During the movie, however, the defendant said that he went and wrote a check for child support, which was new. I mean, we were asking for every detail he could remember, so it didn't really jump out to me as something odd. But then the time he went to bed was about the same. The time he woke up the next morning was about the same.
In this conversation on the 29th, where did he say they were positioned in the living room while they were watching the movie?
He said that Dylan was on one couch and he was on the other couch, and they were throwing the football back and forth. And this is when he told me the football was a Nerf football, which is the first time that he said that. He had never given me the detail. He just said the football. So he also described the football scene, and he said when Dylan missed it, he spat blood on the floor. And Mr. Redwine said, "Don't do that here," that sort of thing.
So that his story was Dylan had gotten hit in the face with the football, the Nerf, causing him to bleed, and then Dylan spit on the floor.
Correct.
Did he also tell you again that he had roughhoused with Dylan on November 18th, 2012?
Yes.
And how did he describe that in this conversation?
He again said that they roughhoused, but Dylan was not hurt during the roughhousing. It was throwing the football, like he had said before.
What did he say about November 19th, 2012?
The defendant told me the same timeline, that he woke up at 5:45, that he did see Dylan over there. He added, and again, we were trying to get him to add details, and he added the detail that he saw a backpack open and some black shirts on the floor. He said something to the effect of, I'm not your mom, I'm not here to clean up after you. And he got the shirts, black shirts, and put them back in the backpack.
He being the defendant, saying that he himself put Dylan's black shirts back in his backpack.
That's correct.
And what did he say to Dylan at that time?
Something like, I'm not your mom to clean up after you, words to that effect.
And that was what the defendant said took place on the morning of November 19th.
Yes, but Dylan was not awake to hear those words.
What were their tentative plans for that morning at around 6:30 a.m., Agent Grusin?
the plans were for the defendant to take Dylan over to Ryan Nava's house at 6:30 in the morning.
Instead of taking Dylan to Ryan Nava's house at 6:30 in the morning, what did the defendant tell you he did?
He said he went to work and went to the attorneys, and just like before, he tried to call and text Dylan and came back home at 11:30.
Do you recall which route he took to get back home at 11:30?
Yes, he said he went through Bayfield.
What was the reason he said he went through Bayfield to return home on that day?
He said he went through Bayfield to see if he could see Dylan on the way back.
Anything that strikes you about that?
Well, Bayfield's quite a ways from his house in Vallecito.
You say it's about 20, 21 miles?
Correct.
What truck did the defendant say he was driving on November 19th, 2012?
He said he could not recall if he was driving the Chevy or the Dodge that day.
And again, does he then take you through what time he arrives at home, and that being around 11:30?
Yes.
In this conversation on November 29th, what else did he tell you about his arrival home?
He said that when he got home, Dylan was not there, so he looked for the fishing pole in 3 logical places for about an hour.
And that search for the fishing pole, according to the defendant, took an hour.
Correct.
What did he do after that hour-long search for the fishing pole?
He took a nap.
And did he again mention that he checked Tristan's and Fernando's houses for Dylan and that Dylan had not been seen at either?
Yes.
What did he tell you at this point about going to the Bayfield Marshal's office and what they did in response to the defendant's visit there?
I believe he said they put out the defendant said Bayfield put out a missing or endangered person notice for Dylan.
That's what the defendant told you.
Correct.
What happened at this point of the conversation, Agent Grusing?
Once he had run us through the timeline again, I started going through with the defendant of what he thought might have happened to Dylan presently, as far as the world of options that he figured.
What were those options that you discussed?
Well, he said there's less than a 5% chance that Dylan ran away. And in our first conversation, he said that's what he thought happened, is Dylan ran away. So that's fine. But then we went on to, well, we're working with Mr. Redwine, saying that we had canvassed the neighborhood, the sheriff's office had. We don't see a sign of Dylan walking down to the lake.
When you say, I'm sorry to interrupt, but when you say you don't see a sign, what are you referring to?
There was a canvas for any video footage from the Redwine residence down to the lake.
Go ahead, sorry.
That's okay. And there was no reports or film or anything of Dylan walking that direction.
So go on, please.
So we went from then him running away to possibly a stranger abduction. And I said, we've done a thorough neighborhood. Actually, the sheriff's department had already done that, and we don't see a stranger abduction. And Mr. Redwine agreed with that.
So at this point in the conversation, he's saying less than a 5% chance that Dylan would run away, although that's different than what he said 2 or 3 days earlier. And he agrees with you, seems a stranger abduction is not possible.
Correct.
What happens next?
So then, I don't recall if it was myself or Mr. Redwine that introduced, the next thing, and that's that a wild animal got Dylan. And I interjected, I believe it was me, that said, well, what a bear? And Mr. Redwine, he got animated and said, yeah, there are bears around here. A bear could have got him, or words to that effect. And my son was a year younger than Dylan at that time, and I felt,
Objection, relevance.
Why don't you ask a question and we'll see if it's relevant or not.
Sure. Thank you, Your Honor. Agent Grusing, after the defendant became animated about the possibility of a bear attack being the reason that his son is gone.
Objection as the form of the question.
Well, there's no question yet, number one. And he's explaining when he's referring to the agent to, so it's fine. Go ahead.
Thank you, Your Honor. So what was your reaction, Agent Grusing?
so Mr. Redwine's reaction was not what I expected when I posed, "What if a bear took your son?" And I told him.
What do you mean by that?
He got excited, almost animated at the possibility.
And that struck you as what?
Objection to ask and answer. We're now retreading this ground. Retreading this ground.
Overruled. Go ahead.
I just found it an odd statement, being a dad myself.
So what was your reaction to the,
Objection moved to strike. That was the exact same answer as prior and the relevance objection prior to that.
Well, I think it is relevant. You're talking to somebody, you're noticing what you think is odd behavior. It leads you to do an additional investigation. If you're a law enforcement agent, it is something that the jury can consider. They don't have to accept it, but it is relevant. Go ahead.
thank you, Your Honor. What happened next, Agent Grusin?
So at this point with Mr. Redwine, we had exhausted the possibilities outside of him for what happened to Dylan. And I told him that I had worked a lot of cases like this, and I did not think that when Dylan came to town, he intentionally meant to harm Dylan. So I said an accident probably happened, and we need to start talking about what happened.
What's the reason you said that to the defendant at that point?
Objection, Your Honor. The basis for this speculation is not admissible.
Overruled. Go ahead.
Agent Grusin, you just explained what you said to the defendant at this point in the interview. What was the reason you were saying that to him at that point?
I wanted the defendant to tell us what happened to Dylan, and I told him that he could either cooperate with the investigation and let us know what happened, or he could get in the way of justice as it came down upon him.
Objection moved to strike. That's the get in the way of justice remark from the FBI is not admissible evidence.
Being offered to try, I mean, the agent did it to try and get a statement from Mr. Redwine. I think it is admissible for that purpose. Go ahead, Mr. Doherty.
Thank you, Your Honor. So what specifically did you say to the defendant at that point, Agent Grusin?
Well, I've used an analogy before with people in his position, that it's like you're on the side of a mountain and a big boulder is about to fall on you. And you can either get out of the way, or you can just let it roll down upon you. And that's just a picture that I gave him to say, you can help us with this thing, or based upon what we know to date, the investigation, your statements, et cetera, that, eventually justice is going to come.
Your Honor, objection to this line of questioning, these answers, and move for the court to provide a limiting instruction that might be a threat that the FBI offers to citizens in trying to intimidate them, but that's not something that can be considered for the truth of the matter.
It certainly is not something that a jury can consider that that's what's going on or that's true. It's solely being produced to you to understand the defendant's reaction, the defendant's statements, and why this agent did what he did. Go ahead.
Thank you, Your Honor. And upon explaining this to the defendant, Agent Grusin, what was his physical reaction?
The defendant leaned forward and his shoulders slumped and his head went down. And we just let him think for a while.
What did he say?
He eventually said, "I've got to think about myself."
And was that the last statement that he made in that interview?
It was, sir.
I have nothing further for Agent Grusin. Thank you, sir.
Okay, Cross.
The remark about the likelihood of running away, that was made several days after you arrived in town, right?
That's correct.
So at that point, makes sense that Mr. Redwine is reassessing based on time passing.
Yes, he could be.
You mentioned telling Mr. Redwine that there was film of the street and that was something described to him, but that was more of a technique, right? That was not a true statement. That was an effort to get Mr. Redwine to talk, right?
No, at that point, we had no video of Dylan walking down that road.
Right. And ultimately, law enforcement did seek to get surveillance footage from people in the area, and that surveillance footage did not show the road. So you're not making a statement of fact in describing what you told Mr. Redwine.
No, I'm saying to the best of my knowledge, we had no film. And again, I'm not out doing these things. We are meeting together as a group. And that was a question asked. Is there any trail cams, ring doorbells, that sort of thing that showed Dylan walking from the house down to the reservoir? And there was none.
So the jury shouldn't take that to mean that there's some film out there showing County Road 500.
Objection, Your Honor, asked and answered.
That's fine.
Okay, I'll let you do it, that's fine.
Well, if you're going to let me do it, I'll.
Just to clarify. So could you answer that question?
Sorry, what was the question?
That there's no film that you're aware of County Road 500, right?
Correct.
And in a similar vein, part of having the backdrop of the big FBI evidence response team vehicle behind you is to signal to the citizen that the federal government is now here.
Yeah, he knew we were there from the past couple of days. But yes, the purpose of that was to let him know that the search was going to be very thorough for Dylan.
And that there would be a lot of resources brought to bear.
Yes.
And that was, in fact, something that you were describing to him, that alternate light sources will be used and other techniques. A lot of techniques are going to be brought into your homes. Right?
That's correct.
One of the resources that the Federal Bureau of Investigation would have available to it is recording devices. Agreed?
At that time, we did not record our interviews.
That wasn't my question. You had available to you recording devices, correct?
Yes, we did.
The conversations that you're describing with Mr. Redwine and the characterizations that you're giving to that conversation is not something that we'll be able to listen to on our own, because at the time, the FBI was not recording conversations, right?
That's correct.
Has there been federal legislation passed that requires that these sorts of conversations be recorded in the interim?
I don't know about the legislation, but starting a couple of years ago, if we're assisting a local agency especially, we are to record along with that agency's procedures and protocols.
You mentioned, and I don't know if it was something that you were catching. Folks who've been sitting in this room for the last several weeks would be aware of the fact that a call to Elaine Hall might catch someone in this room's attention. But what Mr. Redwine was in fact saying was that he reported his concerns to the marshal and to the child's mom. Or are you standing by the notion that it was a call as described by Mr. Redwine?
I couldn't tell you the difference between the two at this point.
You mentioned that Mr. Redwine was adamant that Dylan was not injured in the days leading up to the November 29th conversation, right?
Yes.
But again, that adamance is something that you're assigning to it, and we'll never be able to listen to it to determine for ourselves, right?
That's correct.
And Mr. Redwine said, and this was left out, so it stands out to me, but Mr. Redwine said that there might have been an injury to Dylan, right?
When did he say that?
On November 29th.
Correct. You mean after the lip sore thing?
Well, I'm having to rely on things you wrote because there's no recording of these interactions, but what you
Objection,
wrote.
Your Honor.
I agree. Just try and keep your editorial comments to yourself, Mr. Moran, but you can provide him with what he wrote if it's different than what you're hearing from his testimony.
Do you recall writing in your FD 302, that's what the FBI calls police reports, right?
Correct.
And you wrote in there that Dylan was not hurt, but might have gotten a cut, right?
On the 29th?
Would it refresh your recollection to take a look?
Sure.
Professional approach.
Yes.
Yes, it does.
Back in 2012, when this was written and it had to be signed off on by another special agent from the FBI who was present, you wrote that Dylan was not hurt but might have gotten a cut, right?
Correct.
And the testimony today was that Mr. Redwine said that there was something. Isn't that right?
Yes.
The characterization of spitting that you've given to what was described to you, this jury shouldn't understand that Mr. Redwine was describing Dylan hawking a loogie, like drawing up spit and just spitting all over the living room, right?
He said he only spat in one place.
Like,
he didn't demonstrate for me, though.
You had not reviewed text messages between Dylan and his mom in November, had you?
No, I had not.
So you wouldn't have been aware at that point when it was standing out to you that Dylan would have come from Colorado Springs and then run away. That, in fact, Elaine, the child's mom, had been saying, make your dad wait, that kind of thing, when Dylan arrived in Durango. Did you know that kind of acrimony existed?
I knew there was acrimony. I did not see that text.
So that specific thing you weren't aware of, but you did know that between Elaine Hall and Mark Redwine, there was very significant acrimony.
Yes.
You had some discussion about Dylan's brother, Corey Redwine, and your interactions with him on direct. Do you recall those questions?
Yes.
And fair to say that the conversations you were having with Corey informed next investigative steps for you?
They assisted, yes.
To include Corey's statement that he didn't think that his father would harm his little brother Dylan?
Yes, I don't think either Elaine or Corey thought that he was going to harm Dylan.
When you were in Mr. Redwine's house, were you able to smell decaying bodies?
I was not.
Did you see indication of significant efforts to clean, for instance, smelling bleach, pine sol, anything of the like?
No.
Up until the point, you mentioned on direct that you wanted to avoid being confrontational for the first few meetings with Mr. Redwine, right?
Yes.
But there was a point when you decided that confrontation was necessary, and that's when you start talking about boulders rolling down on him, right?
Yes.
And the full weight of the FBI sort of sentiment being provided to Mr. Redwine.
I don't think that's how it was characterized.
That is an impression you mean to create, starting with ERT truck behind you and moving through saying to Mr. Redwine things about boulders crushing you, right?
Yes, again, my goal was to find Dylan, and I did not believe he was being honest with us. And I felt that if I was able to show him that the truth would come out somehow, maybe he would change his story.
So intimidation is a way to put that, right?
Objection, Your Honor. I'm pretty sure the witness didn't just say that.
No, this is a characterization from the defense, and you can answer whether or not it was intimidation or anything else, and the jury can decide what this tactic consisted of. So it's fair.
My intent was not to intimidate Mr. Redwine. My intent was to get him to tell the truth. And I'm not one to yell at people or scream at people. I thought that using an evidence truck and saying the search would be thorough and talking to him about his options would help us find Dylan.
working for the Federal Bureau of Investigation since 1996, you've become aware in the course of your career that individuals faced with that sort of power, the power represented by the FBI, do on occasion feel intimidated.
Yes.
And after the confrontational description, or after the confrontational interaction began and the description of the boulder happened, that's when Mr. Redwine for the first time starts saying, I need to start thinking about myself.
Yes.
And up until then, his focus had been on providing you information about Dylan Redwine, right? I know you interpreted it differently, but Mr. Redwine was giving you information about his son up until then, and that's when he stopped, right?
Was cooperating with our investigation, yes.
So the confrontation happened, the end, with Mr. Redwine.
Correct.
Thank you, sir. Nothing further.
Redirect?
Yes, Your Honor, thank you. Agent Grusing, throughout the days that you were in Durango assisting the La Plata County Sheriff's Office with this investigation, were you getting regular briefings from the other investigators at each one of the agencies on what was taking place?
I was.
And was that some of the information that you were using when you were interviewing the defendant?
Yes.
And some of the information you were using, when you were highlighting for the defendant why his story or stories did not make sense?
Correct.
And you pointed out that at the time, the FBI did not record their interviews.
Yes.
If the interview had been recorded, what would the jury see?
Well, they would see Mr. Redwine.
Asked and answered.
I'm not sure. What would the jury see? So let's hear what your answer is.
Well, they would just see us talking to Mr. Redwine and him demonstrating the roughhousing. They would see him demonstrating the throwing the football. They would see him demonstrating the lip and, the swords and those sorts of things.
And in an effort to document the interview, were you and Agent Humphrey also writing down notes throughout the interview?
That's correct.
And did those notes include the defendant saying in the final version that the football had hit Dylan in the mouth, causing him to be injured, and Dylan then spit blood on the floor?
Yes.
Objection leading mischaracterizing. There's another part to this straight from the report as asked on cross and left out on first direct.
So you had your cross. This is redirect. I think it's fair. Go ahead, Mr. Doherty.
Thank you, Your Honor. So you took notes during the interviews?
Yes.
Yes. And did you then type up a lengthy 5-page report about the November 29th interviews?
Yes, we did.
Counsel asked you if the defendant's focus had been on providing information to find Dylan. Do you recall that question, that line of questioning?
Yes.
Did you believe that focus, that information to be 100% truthful?
Your Honor, permission to approach if this question may be allowed. Assessments of truthfulness are to be made by the jury. This individual,
Mr. Doherty, want to respond to that?
Sure. Your Honor, counsel just asked Agent Grusing on cross-examination, wasn't the defendant focused on and had been providing information to find Dylan? To complete the context of why Agent Grusing then follows up with the defendant, I think it's relevant for the jury to know Agent Grusing's understanding of those statements and how they compare to the other evidence in the case and compare to the previous statements the defendant had provided to the FBI and all the members of law enforcement in the 10 days leading up to that final interview.
Okay, I think the jury has heard all of that. I do think it is a comment on truthfulness, and so I'm going to sustain the objection.
Counsel asked you a number of questions about the federal government is now here and the search will be very thorough.
Correct.
The federal government arrives, the search is going to be very thorough. And what does the defendant say to you on November 29th for the first time to any member of law enforcement since Dylan went missing?
objection to this officer's, special agent's ability to comment on what any officer knows. think without that part of it, it's probably a fine question, but
Well, he can answer the question as to himself.
It's the first time he admitted there was an injury to Dylan and that there was blood from Dylan.
I have nothing further. Thank you, Your Honor, and thank you, Agent Cruising.
Questions from the jury? Counsel? Okay, Agent Grusing. Mr. Redwine mentioned that Dylan was upset because he could not go to his friends. So Dylan went off to the video section of Walmart. Have you seen the text? That's with a question mark. I think the real question is have you seen the text to Ryan then after that happened?
I have not.
Okay. To the best of your knowledge, where in the house did Dylan spend the night on the 18th of November?
On the couch.
In the living room?
Yes, sir. Okay, yes, Your Honor.
Did Mr. Redwine say the marshal's office had sent out a missing persons alert?
I don't remember the exact term of the alert he said they put out at this point. I don't think it was missing persons. It was.
But I guess the other question being, I don't care about an exact term, but did he say they did something or not?
Yes.
What did he say they did, to the best you remember?
He said they acted on it somehow, and I can't remember the term that he said, but it was some sort of proactive step they took. It was still on his.
They need to hear, not me.
Okay, sorry.
So, did you everybody hear that?
He took some sort of proactive, the marshal's office took some sort of proactive step. But I don't remember exactly what it was. I don't think they entered him into the system as a missing person or something like
And did you ever follow up on that yourself?
that. I did not.
You did not? Okay. Any follow-up on that from you this time?
Yes, Your Honor, thank you. Agent Grusing, is there anything that would refresh your recollection as to what the defendant said that the Bayfield Marshal's Office was doing in response to the defendant's visit to the Marshal's office?
Yes, it'd be in my report.
Your Honor, may I approach?
You may. What page are you referring to?
Agent Grusing, does that refresh your recollection?
Yes, it does.
And what did the defendant tell you the Bayfield Marshal's Office had done in response to his visit there?
What they called a wellness check.
And that to you was a flag that they were taking some action,
Correct.
according to the defendant.
That's correct.
And just to clarify, the defendant's statement to you was that Dylan had slept on the couch in the living room that night.
Yes.
Your Honor, nothing further. Thank you, Agent Grusing.
Mr. Ray?
And as you were aware, when Mr. Redwine said that, Bayfield Marshal's Office, the Potter County Sheriff's Office, the Potter County Search and Rescue, all of those agencies had done something that could be considered a wellness check, right? They were out at Mr. Redwine's house. Agreed?
Yes.
Okay. And that happened on the 19th, right?
Yes.
And you weren't in town for 6 days later.
That's correct.
So when Mr. Redwine's telling you that there were proactive steps taken, that's accurate. They were taken that very day, law enforcement search rescue at Mr. Redwine's home, correct?
Yes, I didn't verify that with Bayfield.
And based on what you understand about this case and investigation, Bayfield Marshal's Office did follow up, right?
I don't know.
Thanks. Let me-
All right, anything else from the jury? Can this witness be excused?
Yes, Your Honor. Thank you.
Yes, thank you. Thank you, Agent. Prosecution's next witness?
The people have completed their case in chief.
Okay, so you're resting?
Yes, Your Honor.
All right, ladies and gentlemen, there's a couple things that we're gonna need to do, before we go any further, so it's probably a good place to take a break for you. So we'll let you out a little bit early, tonight. Want you back here tomorrow at the same time, 10 to 8. We'll start as soon as we can, after 8 o'clock. Again, please do not discuss this case amongst yourselves or with anyone else during the course of the trial. Do not initiate, post, or respond to anything about this case on social media. Keep an open mind throughout the trial. Reach your decision only during your final deliberations. Do not permit any third person to discuss this case in your presence. If anyone attempts to do so over your objection, please report that to me. Don't attempt to gather any information on your own. Don't engage in any outside reading on the case. Don't visit any places mentioned in the case. Don't read about the case in the newspaper or obtain information about it from the radio, television, internet, social media, or any other source. Don't try and learn about the case in any way outside of this program. So, thanks for your attention today. We'll see you tomorrow morning. Okay, the record can reflect that the jury has left the courtroom. Are there any motions? Get to the microphone, please.
I'm just informing the court there is a motion. We just need a moment to prepare.
All right.